father of a daughter with special needs, and I have a grandson who suffers from pretty bad autism. So I understand a little bit about what all of you are going through. And as long as I'm around, I'm going to be able to take care of my daughter and my grandson. And as long as you're around, you're going to be able to take care of your kids too. The problem really starts after we're gone. So we have a lot of different speakers today talking about different phases of this. So I'm going to talk about special needs trust, but they're only a tool. Evelyn Alvin is going to talk about planning, which is really where you start. So we're going to start in the middle. These are the members of our law firm, the lawyers, Ethan, myself, Adam, Marianne, and Emily. And we have a total of 22 people, so we try to give pretty good customer service. So the Hartford Insurance Company made a study a few years ago, and what they discovered was 62% of parents have no plan at all for what happens after they're gone. 26% of parents spend at least $500 a month on their kids, but they have no plan for where that money's going to come from after the parents are gone. 65% of parents have life insurance, but mostly it's term insurance, and the term insurance lapses before the parents die, so they don't collect anything. 50% of parents leave money outright to their kids. And we're going to talk a little bit about why you shouldn't do that. 58% name their special needs kids as beneficiary on their life insurance, their retirement account, or their annuity. And we're going to talk about why they shouldn't do that. And only 25% of parents with kids with disabilities actually have a special needs trust. So what is a special needs trust? Well, a special needs trust is a document, and basically it is funded when you die with your assets, not your kids' assets. And that's very important because there are two types of special needs trust. One is what we call a third-party special needs trust. That's funded with your assets, and the rules are very, very different than if you leave it to your kids and they have to fund it with now their assets. Then there's a payback, a lot more supervision. So you want to fund it with your assets. The child usually has a disability, or looks like they're going to have a disability. There's no payback on death. So when you fund a trust for your child dies, typically what you do is you leave whatever's left in the trust to your other kids. You set it up during your lifetime. Usually you make it revocable because you want to be able to change it if circumstances change. And there's no limit to the age of your child. If you have one of these first-party trusts, they have to be 64 or under. But for this kind of a trust, they could be any age at all. Okay, so why do we want to do it? There are a lot of means-tested public benefits, and Emily's going to spend some time talking about that. But typically, there's SSI, there is Medicaid linked to SSI, and if you are eligible for SSI, you can't have more than $2,000 of assets. If you have more than $2,000, you lose your SSI, you lose your Medicaid that's linked to your SSI. A lot of kids get Medicaid waivers, but in New Jersey, there's usually an asset limit of $2,000 for that. So if you leave the money again, they lose those benefits. There's publicly assisted housing, there's food stamps, they all have income and asset tests. So if you leave your kid money, all of those benefits are going to be lost. But if you leave the money in a trust for your kid, they don't count that income, they don't count those assets. So you really want to maintain those benefits, and you want the money you're going to leave your children to supplement those benefits and make their lives better than they otherwise would be. So Ellen's going to talk about how these trusts work, but people are afraid, gee, I'm going to put my money in a trust and nobody's ever going to see it again. But the kid will see it again. So if your child has mental capacity, well, typically the trustee will get them a credit card and they'll set up a budget. And if there's something in the budget, they just use their credit card, or sometimes they give them a debit card. So if they go get gas, they don't have to call Plan New Jersey or Life Enrichment Trust on the phone and say, I'm at the gas station, it's $54.62. Will you wire them money? Because they have the debit card or the credit card to take care of that. So it really works very easily. All right, next we're going to talk about immediate cash needs. When we meet with our families, we always say, what standard of living do you want to have for your child? So it's kind of broken into sections. What's it going to cost for shelter? What do they need for transportation? Will they be able to own a car, drive a car? Who's going to pay for the car insurance? How much is that going to cost? How much is gas going to cost? All of those things. What are they going to need for personal needs? What do they need to buy at a drugstore? How about clothing? How about shoes? How about food? All of the expenses that they're going to need, we kind of make up a budget. So that's the standard of living you want your child to have. Okay, so then when you die, you have another meeting with the trustee, and they do the same thing. Okay, so now here's the amount of money we have. This is what we need to spend it on. And so everybody knows what you have going forward. So then there's funding the trust. How much money do you need to put in the trust to establish or to fund the lifestyle that you decided you wanted when you made out the budget? So that's really important. Normally, by the way, we don't fund it until you die. See, people get confused. They say, gee, if I take $300,000 and put it in my son's trust, what am I going to live on? Well, you don't do that. You wait till you die. That's when you put it in your son's trust. So how much are you going to need? Well, how much do you need to take out of the trust every year? So there's what I call the 4% rule. And in this context, I call it Tom's rule, I being Tom, so it really isn't terribly valid, but it's a starting point. So where did I get it? There was a guy in the 90s who wrote a paper, scholarly paper, and the question was, when I retire, how much can I take out of my retirement plan every year so it'll last as long as I last? And typically the guy said, you're going to live about 30 or 35 years after you retire. So I'm looking at this and I saw a study that said kids usually last 30 or 35 years after their parents die. So I said, why don't we take his 4% rule, carry it over to special needs trust? So that gives you an idea. You can probably take roughly 4% a year out every year for your special needs child. So if that's true, how much do you have to put in? Well, you would take the amount of your budget, that's monthly, multiply by 12, so that'll give you your annual need. Multiply that by 25, which is your 4%. That's how much money you need to put in the trust. So it's going to vary with everybody. It's going to vary with two things. One, what you want your child to have. Two, what are you able to afford for your child to have? So what we often see is parent has 3 kids. They love all 3. They want to divide their estate equally between all 3. But once you start to do this exercise, you realize it's not going to work because 2 of the kids can work, support themselves. 1 kid can't work. You're going to have to leave him a little bit more if you want him to be able to achieve the standard of living that you said you want them to have. So sometimes you leave 60% to the child with disabilities, 20% to the healthy kids. Sometimes you don't leave anything to the healthy kids. It all depends on your situation, but it's something you want to think about in the beginning. Now, sometimes you don't have enough money to fund the trust the way you want it funded, so you go out and buy life insurance. Now, term insurance is never a good way to fund a trust. Why? Because statistics show that typically the individual buying the policy dies 94% of the time before the term expires. That's why it's cheap. They never have to pay. So if you have a policy for $1 million to fund your child's trust, but you die 2 years before the trust, 2 years after the term policy lapses, there's nothing to fund the trust. So it's better to get what's called a second to die policy. You get, if you're married, you get a policy on you or your wife, and it's not funded until the second death. But it's going to be there when the second person dies. All right, next we want to talk about retirement accounts. Remember in 2017, we got the big tax cut? We all heard about that, right? It was a good thing. In 2019, we got a tax increase. Nobody heard about that. It was called the Secure Act. Should have been called the Insecure Act, because here's what it did. Before the Secure Act, when you died, your kids could take your retirement money out over their life expectancy, which was typically 33 years. So if you left your child $1 million in a retirement account over their lifetime, how much do you think they would get? $3.2 million. Why? Because the money stayed in there and built up tax-free over a 3-year period. Now they have to take it out over 10 years. So instead of getting $3.2 million, they're going to get $1.3 million. They lost about 2/3 of the money. So, but I belong to an organization called the Special Needs Alliance. And when this act was going through Congress, we were able to get a friendly senator to slip an amendment in the bill in the middle of the night that said it doesn't apply to a child with disabilities. So if you have a child with disabilities and you're going to set up a special needs trust, you leave your retirement account to the special needs trust. They still can have the big benefit. And if you want to leave 20% to the other kids, you have what we call an equalization clause in your will or your trust that says they get something else, not the retirement account. So they're still going to get the money, but you want to benefit your kids, not the IRS. Get the idea? So that's really an important thing to understand. So who could you have as a trustee? Well, there are different organizations. One is a disability organization. These companies are nonprofits. They only handle money for people with disabilities, and they don't have CEOs who make a whole lot of money, I don't think. And so they are able to handle smaller accounts and give a lot of attention to the kids. Some banks are very good, but I can tell you from experience, we've been doing this a long time. We've worked probably with banks all over the country, and a lot of them don't have good customer service. A few do, but I obsess over customer service. I told you I have a grandson with autism, right? So let's suppose he's starving to death and he ran out of money. Is he going to call this national company that won't reach out to him and say, I'm starving to death, I need money? No, he's got autism. He's not going to do that. So he needs somebody who's going to reach out to him to be proactive. So you want whoever you pick to be on the ball and reach out to these kids. Don't rely on the kids to reach out to them. I obsess over customer service. About 25 years ago, we were trying to improve our customer service. we found out that the Ritz-Carlton Hotel has a course called Legendary Customer Service, and we took it. And that's what we provide for our clients, and that's what we want our trustees to provide for our trust beneficiaries. A family member, usually the terrible idea, but that's what everybody wants to do. Why is it a bad idea? Because they have to follow all of the rules of these public benefit agencies. They're complicated rules. They keep changing the rules. So every Saturday morning, I go on the Social Security website and I look at what changes they made in what they call the POMs. So I'm familiar with the rules changes. The professional trustees do the same thing. Johnny's sister does not do the same thing. So she sits down in the beginning, says, what are the rules? This is what I'll follow. But then next year the rules changes. She's still doing the old rules. So the child loses the benefits. She gets sued personally, has to pay the money out of her own pocket. And we just had one where this was a $200,000 that somebody had to fork over to Medicaid because they did things the wrong way. So once you tell the kid you're personally responsible, they don't want to be the trustee. And I wouldn't want to be either. So family members never a good idea. The professional trustees will work with a family member, and they want to work with a family member because they want to do a good job. Okay, so when you're doing this planning, you want to also think about the child. If you have a child with capacity, usually they don't need a will because they're only going to have probably $2,000. So they could set up an account jointly with one of their siblings. So if they die, it just goes to the sibling. But they should have a medical power of attorney, letting the parent or a sibling make medical decisions for them if they can't make it for themselves. Because if they've reached that stage, they can't make medical decisions, what happens? Well, either the doctor's going to make them, or a judge is going to make them, or somebody's have to be appointed guardian to make them. Wouldn't it be easier just to have a medical power of attorney? So when you do your documents, have a medical power of attorney for your child. Let them do a medical advanced directive for mentally ill kids. Now that's complicated. A lot of mentally ill kids don't want to sign it, but it's something that ought to be thought about because it gives you a lot of authority without having to go to court and have a guardian appointed. You want to do a financial power of attorney. Supported decision-making is a hot topic, and it's a good idea, but I can never figure out why you need it if you have a financial power of attorney. But there are situations where you do want it. Guardianship is to be avoided whenever possible. Now, my partner Ethan does guardianships all day long, so he doesn't like to hear me say that, but you know, if you can avoid it, avoid it. Sometimes you can't, you have to do it, so you do it. Okay, then what happens when your child turns 18? A lot of times the child's not getting SSI when they're under 18 because they're looking at the parent's income and assets. But once the child's 18, they don't look at the parent's income and assets, so they're eligible. A lot of parents don't know that. So we have people coming into our office, they get a kid 35 years old, is he getting SSI? No, how come? Well, we applied when he was 15, they said he's not eligible. Well, he is now. So apply. Do a guardianship if you have to. And by the way, if you have a child under 18 not getting SSI, then set up a support trust and have it switch over to a special needs trust on their 18th birthday, but have it in place. And also, what we find is if you're providing food and shelter for your disabled child on SSI, the payment's reduced by a third, which is about $300 a month. If you charge them rent of about $500 a month and it's paid out of their SSI, they don't get that 1/3 reduction. So it's simple, sign a lease, which will make up for it. Again, don't give money to the government. Give it to your kid. They're going to need it.